Welcome to part 2 of what is an office action and how do I go about responding to them. The first video explains what an office action is. So if you're watching this, you've received an office action, you're trying to figure out what to do with it. Do I need an attorney to help me with it? How do I deal with this? This video, we're going to be delving into exactly what an office action is and the different types of office actions. First video is going to cover what are known as substantive office actions, and the next video is going to cover what are known as procedural office actions because they're handled differently, and one is a little bit more difficult to respond to than the other. A substantive office action is, in essence, a refusal by the United States Patent and Trademark Office to register your trademark until you argue as to why you should be allowed to register that mark. There are several different types of substantive office action refusals, but the two most common types of refusals are likelihood of confusion refusals and descriptiveness refusal. Likelihood of confusion refusals are basically telling you that there is another trademark out there that they think is too similar to the mark that you are trying to register, and therefore they are going to block you from registering your mark until you overcome the refusal. You can overcome the refusal in two different ways. The two most common ways of overcoming the refusal are arguing around it. So you submit an argument to the United States Patent and Trademark Office saying, hey, thanks, I've received the information saying you don't think this should be registered, and here's why I disagree with you. Those arguments need to be drafted in a very particular way. And the United States Patent and Trademark Office really wants to see certain things. The second way of getting around them is by consent. So if there's another mark holder out there that you have, greater rights to the mark than they do, you can oftentimes approach them and ask them for an agreement saying, hey, we don't have issues with each other and we'll let this one through. The second type of substantive refusal is a descriptiveness refusal. This means that your mark is descriptive of what it is that you sell or do. Examples of descriptive trademarks would be like fresh baked bread for a bakery or fast car wash for a car wash. Generally speaking, everybody needs to use these words or combination of words to describe what it is that they're offering under their services. So the United States Patent and Trademark Office will not grant descriptive trademarks registration unless you can prove that the mark has acquired distinctiveness, or also known as secondary meaning. You can acquire distinctiveness in two ways, either through length of use, and that requirement is 5 years, or by becoming famous. None of these substantive refusals should be responded to lightly. You should take them very seriously and really consider whether or not you want an attorney to help you with them, because if you don't do them the right way the first time, you don't get a second chance to do it again. Remember to be very cautious when you are considering filing your own response to a substantive refusal, because there is a correct way to do it that gives you a better chance at getting it through. We do have a free option and a paid option to discuss your substantive refusal if you're interested, and we look forward to speaking with you.